What if the lyric that was supposed to finish your rival becomes the line that finishes your lawsuit? What if the punchline you launched as a weapon loops through the air, gathers speed in the court of public opinion, and returns in a courtroom aimed straight at the person who threw it? What if the question a judge asks isn't who won the diss, but can you live under the same standard you demanded for your opponent? Tonight, we follow the boomerang. We track it from the studio to the timeline to the courthouse hallway, and we ask the most dangerous question in music right now. Did one song, tailor-made freestyle, plant the seed for a legal unraveling because the very rule that would punish a rival would inevitably land on the artist who wrote it? This is Commentary and Opinion. We're analysing public discourse, filings talk, and the way fans, media, and observers have framed this saga. We aren't making factual claims about anyone's private conduct. Everyone is innocent of any allegation unless proven otherwise in a court of law. With that clarity, let's dig in. Let's start with gravity, the cultural kind. Some records are sparks, others are weather systems. Not Like Us wasn't just a track. It was low pressure over the entire timeline. It pulled conversation toward it. It generated 1,000 small storms, dance videos, think pieces, barbershop debates, group chats you forgot to mute. It blurred the line between music and narrative. That matters because once a song becomes a social script, people stop hearing it as entertainment and start using it as evidence. That blur is the birthplace of this entire legal conversation. In that atmosphere, a decision emerged. Take it beyond the booth. Ask the legal system to distinguish art from allegation. Frame the most explosive insinuations as statements listeners believed, statements that caused reputational damage, statements that deserve a remedy. On paper, that's a clean move. In practice, it walks into a trap that courtrooms are designed to spring. Courts don't like one-way rules. If a standard applies, it applies to both sides. If you argue that bars can function as literal claims when aimed at you, a judge will ask whether your bars function as literal claims when aimed at somebody else. That's the equal lens principle, and it is brutal in its simplicity. Now press play on Tailor-Made Freestyle. The track was engineered for maximum attention, vocals styled to sound like icons, taunts crafted to poke the softest spots, winks toward rumor pipelines, a dare that practically shouts, "Say the quiet part out loud." It electrified the discourse, and not always in the intended direction. Many heard it as a cultural trespass. Others saw it as strategic overreach. And for our purposes, it does something even sharper. It paints the equal lens problem in neon. If you want a court to treat a rival's lines as literal, you have to explain why your own provocation, designed to drag whispers into daylight, should be exempt. Not because a judge believes the whispers, because your rule can't be a spotlight that only points at someone else. Flip the switch, and the whole stage lights up, including your half. Imagine the exchange in a courtroom. One side says, "Those lyrics were widely interpreted as factual and caused real harm." The bench replies, "Under your theory, what do we do with your lyrics that nudge the crowd toward the very same insinuations?" If your answer is, "That's just performance," the boomerang completes its arc. Then so are theirs. Equal lens, equal rule, equal result. This isn't about tastes. It's about coherence. Battle rap thrives on exaggeration and satire. It's theatre with teeth. Courts know that, and because they know it, they're slow to police it. They look for clean principles that won't turn the courthouse into a content moderation office. Treating diss bars as affidavits would invite endless bar-by-bar litigation. That's a nightmare for free expression and a full employment plan for lawyers. The equal lens principle becomes the off-ramp. If enforcing your rule requires me to read everyone's lyrics literally, I'm not enforcing your rule. Now, step through the timeline in plain language. A powerhouse diss detonates. The public welds it to a story about a rival. The rival answers with volume. Multiple records, escalating theatre, and finally a spectacle. The track that tempts the culture to join the dots. The internet, already sprinting, sprints faster. And then comes the legal gambit. Treat the lyrics not as metaphors, but as statements a reasonable listener believed. If it works, you reclaim reputation. You chill the worst insinuations, you set a precedent. But the moment the gambit is on the table, tailor-made freestyle becomes Exhibit A in the symmetry test. If lyric as literal is your rule, can you survive it applied to you? The culture piece matters here because it frames how courts and juries perceive arguments. The AI-styled voice choice hit nerves. A lot of fans felt a line was crossed. That sentiment doesn't decide a case, but it colors the room. When you ask a judge to be gentle with art while your most visible move was seen as disrespecting the culture's dead, the optics get rough. Judges are human. Jurors are human. They sniff out gamesmanship, and they do not love the combination of provocation followed by a plea for strict rules. There's also the modern dynamic. Timelines convert performance into truth through sheer repetition. A lyric becomes a caption, becomes a headline, becomes a clip on a newsy channel next to genuine reporting. Context collapses. The algorithm doesn't care what's theatre. It cares what keeps you watching. That's the argument for seeking legal relief. We don't live in a vinyl world anymore. If art is used like evidence, maybe the system must treat it like evidence. But you can't rewrite the First Amendment every time a record goes viral. The smarter legal route is narrower. Don't declare all metaphors actionable. Identify the specific lines that are unmistakably presented as factual assertions, and show that listeners reasonably understood those lines as facts. That's a high bar by design. Rap writers aim for the exhilarating edge where they can imply without asserting, sting without saying, provoke without pinning themselves to the wall. The structure of the craft is plausible deniability. It's what makes diss culture both thrilling and hard to litigate, which returns us to strategy. If you intend to ask a court to treat a chorus like a claim, your own verses must be immaculate. No rumor winks, no say it out loud dares, no name checks that smuggle gossip into the hook. You have to live like a monk in a glass booth because cross-examination doesn't grade on a curve. Consistency is the only currency that spends in front of a judge. If you condemn a tactic and then use it, the contradiction testifies against you without ever taking the stand. Zoom out to the bigger picture. This story isn't only about two artists. It's about how a culture polices itself without strangling the art that made it matter. If courts rule that every diss is a potential deposition, the genre loses the audacity that gave it oxygen. If courts rule that nothing said in a feud matters, real reputational harm can hide behind the theatre. The balance is delicate. Most judges aim to preserve the category, artistic hyperbole, while leaving a tiny window for extraordinary cases where language is clearly factual, verifiable, and intended to be believed. That approach avoids turning the bench into a lyric referee and still acknowledges that words can wound beyond entertainment. Public sentiment will always be the invisible third party. The track at the heart of this conversation didn't just raise legal questions, it raised moral ones. Is borrowing the aura of dead legends to win a modern beef fair play or foul? Does shock value help your point or drown it? The answer matters because reputation isn't only legal, it's cultural. A court can dismiss a claim and the audience can still hold a grudge. The song is the sentence, the chorus is the closing argument, the memes are the jury's notes. You can't file a motion to erase a summer. There's another force in the room, receipts. The timelines archive everything. The same ecosystem that blurs art and allegation also preserves the nudge, the wink, the clipped out of context moment you proudly posted. If your case argues that rumor weaponized in music becomes harmful fact in the public mind, the other side will ask the obvious. Why did you weaponize rumor in your music? Not because they want the court to believe it, because they want the court to see that the only stable rule is to protect art in both directions. If both parties used the same tools, the fairest outcome is to let the music be music and refuse to turn bars into sworn statements. So where does that leave us? 3 plausible paths. 1. Quiet de-escalation. The legal fire cools, the culture moves on, and everyone learns without anybody writing a new constitutional rule on a diss record. 2. A narrow doctrine. Courts reiterate that rap battles are saturated with satire and hyperbole, but leave a tight test for when a line steps out of the ring and into factual territory. 3. The risky route. Someone tries to bake audience interpretation, virality metrics, surveys, algorithmic reach into the legal standard. It sounds modern. It is also dangerous because it turns the loudest reaction into the law. That's a road to chilling effects and artist paralysis. Meanwhile, the equal lens boomerang keeps humming. You can feel it every time the conversation turns back to tailor-made freestyle. That track is a symbol now. It's a reminder that the strategy you choose on Monday becomes the standard someone uses on Friday. If you ask for literalism, you inherit it. If you ask for leniency for art, you must practice it. If you want a rule, be the first to live under it. There are lessons here that every artist should tape above the desk. 1. Write like a judge will hear it. That doesn't mean be safe. It means know which lines read like sworn statements to a neutral ear and either avoid them or be ready to defend them. 2. Never build a case on a standard you can't survive. If your legal argument requires the court to treat bars as facts, scrub your catalogue of bars that behave like facts. If you can't scrub it, don't ask for the rule. 3. Spectacle is expensive. Shock devices win minutes and cost months. If you plan to invoke cultural respect in your filings, don't spend the season before testing the culture's patience. 4. The audience is not a bystander. We share lines like headlines. We caption insinuations like evidence. We give oxygen to rumors because it's fun. If we want less courtroom in our ciphers, we have to stop turning metaphors into breaking news. 5. Reputation is multi-lane. Legal wins can't launder cultural losses. The only way to keep your name clean is to align your music, your message, and your method. If those three harmonize, even rivals have to acknowledge the consistency. If they collide, even fans can't defend you with a straight face. Let's talk about the human factor because it gets lost behind trends and takes. Artists are people with families, teams, and futures beyond a news cycle. Feuds are adrenaline, but the internet bottle keeps the lightning long after the storm. A lyric written for a midnight drop can live as a 10 a.m. boardroom question. A rumor turned into a rhyme can become a line in a lawsuit. The smarter play in the modern era isn't to sand off every edge, it's to choose the edges that won't cut you later. If this legal saga narrows or fades, tailor-made freestyle will still stand as a cautionary tale, not because of who it attacked, but because of the mirror it holds up to strategy. You can win the timeline and lose the principle that would have protected you when the timeline turned. You can win a comment section and lose a judge's patience. You can win a night and lose a season. If the saga continues, watch for specific tells. Does the argument shift away from treat all lyrics as literal toward a handful of lines alleged to be factual? That's a pivot from global to surgical. Does the conversation in court start focusing on context, battle rap norms, satire, performance? That's the system reaching for the off-ramp that protects the category. Do filings reference audience misunderstanding as a core factor? That's the risky road where virality threatens to become the standard. Each path telegraphs a future: freer art with clearer boundaries, or colder art with heavier legal shadows. You might be wondering, can one track truly tilt the outcome? Not alone, but as a symbol of the equal lens trap, it's devastating. It's like leaving your playbook open on the bench. The other team doesn't need to prove every page. They only need to show that your favorite play can't survive your own rules. That's what the boomerang does. It reminds everyone that rules in court are mirrors, not spotlights. So here's the cleanest distillation of the entire story. When music turns into a social script, the temptation is to chase the narrative with bigger theatrics and sharper hints. It works until you ask the law to step in. The law doesn't reward the loudest chorus, it rewards the most consistent principle. If you want the law to treat art as art, act like art is art when you're holding the mic. If you want the law to treat bars as facts, write bars you can defend as facts. Anything less is a wish, and courtrooms don't grant wishes. Where does that leave the rest of us? With choices. As listeners, do we share a bar like it's a sworn statement, or enjoy it like it's a performance? As commentators, do we feed the rumor economy or demand sources? As a culture, do we reward clarity or chaos? The future of feuds might be written less by judges and more by us. If we stop pretending metaphors are confessions, artists won't feel forced to drag referees into the cipher. If artists stop dressing rumors up as winks, they won't feel the boomerang coming back for them in a hearing. The final image I want to leave you with is simple. Not a microphone, not a stage. A mirror. Every argument you throw at a rival reflects onto you first. Treat lyrics literally. Look in the mirror. Punish insinuations? Look in the mirror. Respect the culture? Look in the mirror. If your reflection can stand under the rule you're asking for, you're on solid ground. If it can't, you don't need a better lawyer. You need a better standard. Subscribe to Scandal News for fearless breakdowns and smart receipts. Hit like if this helped you see the bigger picture. Drop your take in the comments. Are disbars performance or proof? Ring the bell so you never miss the next deep dive. Share this with the one friend who argues louder than you. If you made it to the end, comment boomerang so I know you're one of the real ones. New stories every week. See you in the next one.